All right, good afternoon, everyone. So my name is Jean-François Roberge. I will be the moderator for the last session today. So panel 4, ODR lessons learned, evaluations in courts and other public bodies. So we will look into more case studies this afternoon, and we will also look maybe in more details on evaluation of online dispute resolution activities. So this is something, again, that is different from what we've heard today, but that builds on the previous presentations. So we will start with Mr. Frank Fowlie, who will present. His presentations is not going back to old normal. So essentially, we'll look at a successful pivot from bricks and mortar dispute resolution to online work with with initiatives taken into different Canada's administrative public bodies, and more specifically the ones related to immigration, property assessment, and sports. And so that will be our first presenter today. Our second presenter is Professor Ayelet Sela, who prepared her presentation with Professor Orna Rabinovich-Aini, but unfortunately, Professor Aini cannot be with us today. She's located in Israel, so Ayelet will present the presentation on her behalf as well. So Ayelet will look in more details on the evaluation of ODR. She also did empirical research and have results to share with us, as well as the process, methodological issues that can be, or in some point, recommendations on how to evaluate the activities on ODR to, in a way, build the case of ODR, but also to improve ODR processes over time. So you have here, they're both very literate people with a doctoral degree. Frank has his doctoral degree from Australia, and he's been involved. He's currently a deputy chair of the Commonwealth Game Federation Ethics Commission. He served as a commissioner with Athletics Canada, was an ombudsman in very context in different countries and different projects. So he will speak first, and I invite him to come and present his panel on not going back to old normals.
Thank you. Thank you very much, Your Honor. There we go. Before I start my presentation, I just wanted to make a couple of opening comments. Firstly, to Kareem and the folks at Cyberjustice. Thank you very much for putting this event on and for putting it on in Canada. I know from personal experience that it's a lot of hard work, and I think you've done an excellent job. Secondly, I want to bring the greetings of NCTDR fellow Dave Belinsky, who's unable to be here today because he's attending an ABA meeting in Las Vegas, where I assume the weather there is just slightly better than here. And third, I want to remind all of you folks that there is a City of Montreal ordinance that prohibits the throwing of any objects towards speakers at a university lectern. So I am a self-confessed evaluation geek. I did my doctoral work on developing evaluation blueprints for ODR programs, and I look specifically at the program at the Internet Corporation for the Assigned Names and Numbers, which is a little tiny organization that runs something called the backbone of the Internet. So I was quite interested in taking this topic on. We're going to look at a couple of different Canadian examples of ODR organizations and where evaluation has been done very well, where there's probably a need for evaluation, and in one area where there's an ecosystem that is in desperate need to have the whole system as opposed to simply the component parts looked at. So the three bodies we're going to talk about today are the Immigration and Refugee Board of Canada, the Property Assessment Review Panel, and the independent third party for sports organizations and charlatans, as I will say, because it's a bit of the Wild West. And you can imagine my interest and somewhat trepidation when I heard speakers this morning talking about two of the three of the things that I had on my list. I will let you know that the property assessment review panels are in British Columbia, but it is not the same thing as the Property Assessment Appeal Board, which you heard about twice. The appeal board is exactly that. It is the appeal body above the local bodies that are called review panels, and so I won't be stealing anything from any previous presenter. Two things I want you to bear in mind as we start going through this is that I am here today in my personal capacity as an NCTDR fellow. I am not a representative of the Immigration and Refugee Board of Canada. I will not be sharing any state secrets on refugee issues. I know, Leah, you're disappointed in that. So is Scott. He was after that. And everything that I'm going to be citing today is available in the public domain if you were willing to take the time to look for it. The other thing I wanted to talk about in terms of evaluation, and I thought the presentation about Paul was very interesting because it alluded to that, is that it's inevitable that outcomes will drive the sense of justice or the amenability to the process. If you win, you're probably going to like the process. If you lose, yeah, maybe not so much. So the pivot's here to stay. And this is a document that's out from the federal government of Canada. And I just want to scroll down just so you get an idea of the number of guidelines that are now in place across the country for doing ODR in courts or in tribunals, the number of virtual hearing guides that are available for counsel and public, and practice notices on best hearings. It goes on and on. 5 years ago, I would have been a really short list that wouldn't have been a whole web page. So it's here to stay. The government of Canada, in response to COVID, has taken the position, and I think most of the provincial governments have as well, that access to justice during the time of COVID was important. The courts could not stop. The backlogs would have been excessive. The 2-year rules in criminal court for getting people to have their cases heard in court would have gone out the window. And so a lot was done in Canada to make sure that courts and tribunals stayed on course. The IRB is Canada's largest administrative tribunal, and it deals with decisions and appeals on immigration and refugee matters. Well, what does that mean? So in my job, I'm a member of the Refugee Protection Division. My job is to act as an administrative judge to determine whether or not an applicant or a claimant meets the Canadian definition of being a refugee. Are you being persecuted in your home country, and would you be persecuted if you went home? The immigration people deal with people that have overstayed visas, have committed crimes in Canada while they were foreign national, and those sorts of things. So roughly on an annual basis, Refugee Protection Division hears 50,000 cases across Canada, immigration 11,000, and each of those has its own appeal division within the IRB. And so the Refugee Appeal Division does 13,000, which basically goes to say out of 50,000 claims heard, about 13,000 will be negative because it's a free and automatic right to go to appeal. And then IAD does 30,000, so about 80,000 finalizations a year, which is a lot for an administrative tribunal. It's a small organization. It's less than 1% of the population of the federal civil servants. Interestingly, at least 2/3 of the staff are female. Last year, 57,000 claims were accepted. And at the end of the year, 24,000 were done, and we have 103,000 claims in line that we will be receiving from Immigration and Refugees Canada, which is the ministry in charge of that. So we have years of work lined up. That's not including what's going to happen from today forward. So it's a very, very busy place, fast-moving environment. They say that when they hire you. They do not define it. It's a fast-moving, high-volume tribunal. It's a very, very busy place. Now, there was a really good report, and the evaluation geek in me made me probably one of the first people in IRB to read this report. And where's Nicholas? Is he in the room? Valentin? Oh, there you are. Yes, so Nicholas was the principal investigator. You were the secondary investigator. And I have to tell you, in my years of reading evaluation reports, and there aren't that many that deal specifically with ODR, this access to justice question was examined in a thoughtful, deliberate, and useful manner. Sometimes it can be thoughtful and deliberate and be totally useless. This was very, very useful at the end. And I want to congratulate cyberjustice for doing a very good job. So there were 9 major findings, and if I get off anywhere wrong, I want you to correct me, but remember the throwing things bylaw. So most people experience a strong sense of access to justice when they were in a Teams environment as opposed to bricks and mortar. That the survey data didn't always reflect the positions held by the authors or by the immigration consultants. So yeah, that would be normal, because as an evaluator, you really shouldn't have a whole lot of positions. You should be coming in fairly blank and seeing what happens. More data is necessary should IRB decide to continue to offer virtual hearings after the pandemic. So before the pandemic, the default was if you were in immigration detention or if you were a claimant for refugee protection, you would have to go to a courtroom in a federal government building. And it would be set up like a courtroom, and there would be security and all of those hallmarks of a bricks and mortars court. That default no longer exists. The default for providing this service to foreign nationals who are in Canada is now on Teams. And it is the exception to go into a courtroom. I think the only time that I've actually heard an in-person hearing was with an elderly couple from Asia who lacked linguistic and technical abilities. So even with an interpreter online, it wouldn't have worked for them. So to go into the courtroom to welcome them and to hear their stories was important. Virtual hearings can lead to a loss of ritual and practices. I'm not sure that that's necessarily a finding that still exists. I think it's a fairly strong ritual that we've developed that's in reaction to doing it in Teams, and we have a slightly different way of doing it. No one rises when the member comes into the room anymore because the member's already there on Teams. Although I may not be smoking cigarettes and drinking alcohol when I'm doing my hearings, if it's a nice day in the summer, I will have a shirt and tie and a pair of shorts on and look like I come from Bermuda. In concerns regarding witnesses receiving information can be easily addressed, and that's very true. There have been concerns of people texting back and forth or having another person in the room, and we found ways around dealing around that, and those are, again, all found online. Concerns about loss of nonverbal are not warranted, and that's absolutely correct. My experience has been that once you're 10 minutes in, you don't notice the difference. People get very used to it. These are very complex hearings at times because often there's a second language involved other than English and French, which are the official languages in Canada. Often there will be a third language, so there'll be the IRB member, counsel. Counsel will want a hearing in French, and the claimant will be speaking, for example, Punjabi, and there'll be an interpreter that translates from French to English, and then from English to Punjabi, to get it to the claimant, and then it comes back. So the amount of time can change. It's very, very interesting. Concerns regarding the dehumanizing aspect of hearing should not be ignored, and I think that's high on the list of things that members individually, while they are doing their work, try to do. And technical difficulties I don't think arrive very often, and security is fairly tight in terms of the online. So those are the findings that they found. Nicholas, you missed me saying what a good job you did, but I'll say it again.
Somebody texted me to say so I ran.
Oh, is that right? So there's new normal and there's old normal. And again, all publicly available information. So everything used to be bricks and mortars. You had a court time. There were 5 courtrooms in Montreal that were active. It was place specific. You had to be at that courtroom at that time. And if someone lived in Regina or Saskatoon or Nunavut or Halifax, there would be someone who would take note of all of that and fill a secure briefcase with the handcuff on it, because they were classified government documents, and a member would go out to those places and spend a week or 2 weeks hearing files and then come home again until the briefcase got full, and then someone else would go. Now what happens, and again, public information, you can be in Halifax and you speak French, and I'm a French member in Vancouver, so at 8 o'clock in the morning you'll be coming online at 1 o'clock in the afternoon from Halifax. At 9 or 11 o'clock in the morning, your French-speaking lawyer from Montreal, and will happen seamlessly on Teams, as if we were all in the same city. So it's national, the coverage is national, no travel involved for anybody. Counsel apparently love it because they don't have to sit in the court hallway. They're more productive. They have a hearing. They can start taking another file. Claimants love it. I have, people are able to be at their work site. They're able to be at home. The evaluation indicated that all parties like online hearings. Nobody came out in the evaluation to say, oh, that's a bad idea, we don't want to do it. It's great for language choice, again, because it's easy to find people around the country who can either translate or be the interpreter, and they live in South Vancouver and the claimant is in Montreal, whereas bringing them together would cost a lot of money. There's cost savings. If you think about the fact that if a member works at home, they're paying their own electricity, they're paying their own internet, they don't need office space, those things all help the government bottom line. It's also great for the members because they like counsel. They don't have to travel to work. They can stay at home. And it's very flexible. If someone, a member drops sick in Montreal or in Toronto or in Ottawa, someone in Vancouver can pick up the file and the hearing can go ahead. Whereas if it's all sort of face-to-face, that becomes much more difficult. Have I told the truth, sir? Valentine?
Oh, sorry.
Have I? Someone wake him up. Have I told the truth, sir?
Yeah, definitely.
All right, good.
Very well said, and
Thank you.
I'd like to inspire myself with your good presentation.
You'll owe me a beer later. So I want to talk now about property assessment. And again, this is the first level step in British Columbia. This is an area, I think, that because of the linkage between what Simi talked about earlier and what I'm going to talk about now, it's ripe for evaluation. And that's that idea of why do some things go from an ODR process and not work, and there needs to be a further appeal. So And basically, this is the process about how municipalities decide how do they make their budgets. So the tax bill kind of comes out based on the value of a property, based on a prorated amount of the budget. And the higher your assessment, if you have a $5 million home next to a $2 million home, you can expect to pay more in taxes than the $2 million home. And you may want to raise or lower your property assessment. So if you are like me and you've been a long time in your house and your assessment's high, you probably want to say, well, maybe it should be a little bit lower, and you'll save a little bit of money on your taxes. And if you're like my neighbor and you've got your house for sale, you may want to say, well, gee, I'd really like a high property assessment because then I might get a little bit more data to be able to get a higher price for the sale of my house. So there's a couple of really good guides. And again, this was a pivot, and I know from personal effect because I actually went in 2019 through the local Property Assessment Review Board, which was done with 2 members and a chair in the ballroom of a local hotel where there were 3 or 4 people lined up, plus the property assessor who had all his files, and they'd sort of run you through very quickly like small claims court. Well, again, it's a place that pivoted, and then they have all this great information online, as with PAAB, on how to make an appeal, what you should know, discuss your concerns, deal with it on the low level. So lots of self-help information available. And for your concerns as ODR practitioners, there is a standalone evidence system that you can use to put in your information. You're not sending it in by Outlook or by email. And this system is only open during the 3 months that you can make the appeal, from January to the end of March. Once you've gone through that appeal, if you're dissatisfied, then you can go to Simi's old office and ask for another review there. 98.6% of British Columbians do not make an appeal, and I think it's about 4,500 to 5,000 a year of all the properties in British Columbia that actually go to that final appeal step. So again, no more traveling panels, no more hotel ballrooms. It's a user-friendly thing, online filings, it's purpose-built software with a virtual hearing. I think it's ripe for an evaluation to say, how are both of these things as an ecosystem working for property owners? Why are they appealing? What's going wrong in the system? Why are they, what are the issues? And again, this deals with everything from the homeowner to the people that own the largest shopping malls or commercial or industrial space. So there's lots going on there. Last thing I want to talk about, and it's kind of a personal area for me, is the Canadian sports system. So this is an ecosystem. Canada has suffered in the last few years with crises and scandals. If you are Canadian, you will have heard of Hockey Canada. You will have heard of Skiing Canada. You will have heard of synchronized swimming, et cetera, et cetera, et cetera. And government has been reacting to it over a period of time. We have our federal countries, so we have provincial jurisdictions and we have a federal jurisdiction, Sport Canada, which gives out money for the Olympic teams and things like that, and grassroots that are run by provincial hockey associations and those sorts of things. One of the reactions was to have a new commissioner, the Sport Integrity Commissioner, which is countrywide, and they take complaints from anybody on any level of sport. But then each sport has its own independent third-party complaint process. The one for Hockey Canada is costing them a couple of $1 million a year. It's a team of lawyers out of Toronto, and any complaint about hockey goes to this centralized body, and then they decide if it's horrific maltreatment or not, if it's sexual assaults, that sort of thing. The problem is that a lot of there's a few of these providers. So OSIC is kind of mandated by government. It's part of law. It gets funding from the government of Canada. Then the sports do their own thing. And so there's a bit of a wild west out there, And again, it's part of an ecosystem that needs help. And these are all online systems. These are submissions by forms that are available on the sport website in both official languages. It's dealt with by asynchronous communication, and if there's a hearing, those will also happen online because of the displacement of people across this large country. Now, you want to take a look at this link, and if I'm assuming that these are going to be distributed, but that this whole idea about the lack of objectivity in private companies that are providing these services. Some of them, to me, are at the level of charlatans, unexperienced in law, unexperienced in law enforcement, unexperienced in human rights or harassment, but it was a great business plan. And so something to look out for. Very ripe, I think, for an overall evaluation and systems review on how people are being treated in dealing with complaints, especially serious complaints in sport. So I think am I under my 10 minutes, 15 minutes? So COVID was the best thing to happen to ODR in many ways. There's a plethora of virtual tribunals and practice guides available in Canada. There are a couple of reasons that people evaluate, and I just want to go through them very quickly as an evaluation geek. So why would you want to evaluate your program? First thing is you want to demonstrate value. What are you doing and how does that help your organization? Second is it working? Is what we're doing right? What can be improved? What are the successes that we can celebrate? Ensuring service standards, demonstrating integrity, and of course the last one that's very important for a lot of people is to help decision makers decide whether to keep the incumbent in place. So some areas of the public square are still the Wild West, and other places in the public square are doing very, very well. Questions?
Maybe we'll leave
Okay.
the floor open for questions at the end of this session. All right, wonderful. So now, going to move to, thank you very much, Dr. Fowlie, for your presentation. Yes, questions will be, there will be a time for questions at the end of this session. Maybe we can move to the key elements as well, just to let me introduce our next speakers, Ayelet, Sela. So the Professor Sela holds her doctorate from Stanford Law School. She's an assistant professor at Bar Ilan Faculty of Law in Israel. She's a founding member of the BYU Law Data Lab, and a Civil Justice Innovation Fellow at Stanford's Law School. So her scholarship is around the dispute system design, law and technology courts, empirical legal studies. So she will share with us today her methodologies, recommendations, well, in fact, the framework and all aspects of how to evaluate ODR, and with examples of how she did it with public bodies. So, Professor Sela.
Great. Perfect, thanks. So hi everyone, it's good to be here. It's always a challenge to be the last talk of the day, so I hope you're all fresh and ready for the last bit. My talk today is actually a joint talk with Professor Orna Rabinovich-Aini, who sadly couldn't join us today, but I do want to give her the credit. We prepared everything together, of course, and this is actually the result of a joint project that we have been working on for a couple of years, and we're excited to share it with you. So I guess actually Frank set the stage perfectly for this presentation, and in fact the presentations that we've had here throughout the day actually allow me to skip most of my introductory slides. So we all know what's great about ODR. I think we've observed during the break that we're preaching to the choir in this with this particular audience. We all know the promises of improving access to justice and providing even better procedural justice experiences. and of course, improving efficiencies in the justice systems, and potentially allowing more diverse set of outcomes than traditional legal proceedings offer. But what we want to focus today in our presentation on are actually additional systemic implications of implementing ODR technologies with public bodies. And these pertain to, as some other presenters have pointed out today, thinking about how we can do things differently, reimagining what processes and institutions could look like, how technology could maybe allow us to offer additional ways of resolving disputes that we have not thought about before. It's also an opportunity, as I think also Simi's presentation stressed here today, to bring in design methodologies into legal proceedings, into the legal profession as a whole. I actually think we see in the past few years the idea of user-centered design infiltrate other areas of the law, and I think it's to a great extent an impact of the ODR community on broader legal communities. There's this idea that we can embrace process pluralism into public bodies, not just in the sense of offering different types of dispute resolution methods like mediation, arbitration, negotiation, and of course adjudication and so forth, but also this idea of medium pluralism, that we can offer our processes using different communication media, different information technologies. Tomorrow we're going to talk a lot about AI and what that means to process design. And this paves the way for new ways of imagining, again, processes and also introducing new design methodologies into the field. And what we want to focus our presentation on is that last bit, how new opportunities for research and for evaluating the work of public bodies that implement ODR emerge thanks to all these previous characteristics that I reviewed. So we have more data and new types of data that are available now for us to evaluate these bodies. They're much easier to collect. They're very amenable for analysis oftentimes without a lot of additional work by researchers. But of course, there are also a lot of challenges that are associated with this. Just to name a few to get us started, the lack of data standards between different bodies, even within the same bodies, sometimes we don't have data standards, the reliability of data that is provided by these bodies and the way that and because of the ways they collect them, the fact that there is no culture of A/B testing, as was mentioned here earlier today in the comments within public bodies. So a lot of challenges too. And so what we would like to do today is present a case study of joint work that we've done together. If time permits, I may also look at some other projects that allow us to reflect on some of the challenges of conducting research and evaluation within ODR in public bodies. The first one is defining concepts, and I think that actually emerged within the discussions here today, so I think it's useful to be the last presentation of the day. Yeah, what is access to justice? What is it? What does it mean? Is it access to a decision maker? Is it access to the legal information that we need in order to pursue the proceeding? When we're talking about ODR, does that also mean access to technology? But if it's access to technology, is it also equal access to the data that allow us to create new inferences based on that data? What is it? And that challenges us as researchers, and I think also as policymakers, to define concepts that we used to just use them as taglines, access to justice, procedural justice. But when you have to measure them within public bodies, then you're challenged to find useful, effective, operationalizable definitions for these concepts. Then the next challenge is to develop measurable indicators. If you actually want to measure the impact of introducing an ODR program, then you need to find a way to measure that access to justice or that procedural justice or that efficiency. And that's not always an easy thing to do, and I'll share some insights about that as well. And then lastly, and I think this is going to be a big one, and I had a chat with Spinek about this over the break, data. How are we going to get access to the data that we need in order to conduct this research? And getting access to that data is not the end of the road. Being able to work with that data is also key, and we'll touch on that. So with that, I'm going to jump into our case study and try to show some of these insights. I do want to say, though, because I'm talking to an ODR audience, that what we're talking about, and I think a lot of the examples that emerge currently in public bodies, is not that first layer of ODR, the restructured process that is usually only asynchronous and text-based using web forms or wizards and so forth. We're not talking in our case study about a CRT-like process, but rather on the model that became most common during the pandemic, which is either e-management, case filing, document filing systems that were used by judicial bodies, usually asynchronous and with pleadings that are uploaded to a website and then, with very minor forms attached to them, and video conference hearings that oftentimes come after that first text-based stage was completed. And our case study is what is known in Israel as the first fully online tribunal, colloquially referred to as the COVID tribunal, because it heard appeals by businesses. Businesses could be, single professional or a firm or a large company for government that did not receive governmental grants that were distributed to businesses based on certain criteria. And this is an administrative tribunal that was working under the jurisdiction of the Ministry of Justice, and it offered a fully online end-to-end process, which was either document-based, and again, that meant uploading pleading to a website with some very basic forms to it, or based on these pleadings, also conducting an online hearing using Zoom. These appeals, that in terms of the process, were structured in this tiered way, and at any stage of the process, a decision could have been made by the tribunal judge. It's actually a judicial panel. And of course, there was also potential for settling the case or withdrawing it at any stage of the process. This was an interesting body because it had a judicial officer who was legally trained, but the panel was also comprised of a professional that was either a tax advisor or an accountant that brought in this professional expertise into the process. We had appellants that could self-represent, or appellants who would be represented by either a lawyer or a tax advisor or accountant that could represent them. This was a fairly unique model in Israel, the first time that this type of representation was attempted. And it was also interesting to see how lawyers represent differently compared to tax advisors and accountants. It's interesting what lawyers do when they enter the process. So I would say that in many respects, when we had a tax advisor or an accountant represent a party, it was much more similar to self-representation than the processes that involved attorneys on almost every metric that we examined. So just an interesting insight to consider. And then lastly, I'll mention that, I actually already mentioned that we had diverse businesses, but it's important to note because whenever I'm going to say something about self-represented litigants, I want you to remember that these are businesses. So sometimes they're not sophisticated businesses, but they are businesses. Even if it's a plumber that runs a business, it's someone who is able to run a business and that has the infrastructure for that business. So that's an important caveat to remember. Okay, so because it's late, I'm going to start with my key takeaways, and then I'm going to show you the data that supports these takeaways. The first one is that we had overwhelmingly positive findings for all of these different process types and by all participants. So on all of the measures that we examined, whether it was access, procedural justice, efficiency, and the perception of outcomes, we had very positive findings for both self-represented litigants and represented processes, for both video hearings and text-based only processes. But interestingly, having had all these, on average, positive experience, no matter what process and what role you played in the process, at the end of the day, in terms of preference, about 30% of participants still stated that they would prefer to participate in a face-to-face proceeding in the future. And that's interesting. When we talk about process pluralism, I think that's something important to remember as we design these processes. How do we triage early on and figure out who are those people who feel that an online process doesn't treat them well? And actually, as I'm preaching to this choir needs to remember that too. The second thing is medium pluralism. We also found out that there are those people who feel more comfortable using text and those others that feel more comfortable using participating in a video hearing, and that was important to them. Figuring out who are those people earlier in the process would also allow us to provide better access to justice and procedural justice for those people. An interesting finding that's very relevant for this particular panel is the unique challenges that tribunals face when they implement ODR proceedings. And here I want to contrast tribunals and courts. This is actually not a hypothesis or a research question that we had when we started the process, but the data spoke to us, so to speak, as we realized that when citizens engage with the tribunal, they oftentimes are not able to distinguish between the governmental agencies whose decisions are being appealed and the tribunal. And that becomes very difficult when all you have is different websites and you click through them. And so there's an important role for user interface design, process design, and also some of the messaging that goes into, it goes to the parties. And there's a role here for the tribunal to actually make sure that its independence and neutrality are more apparent to the parties. But really the key insights that I'm focusing on are on those second line of the slide. We encountered as we were doing this, and we had really tremendous participation from the tribunal that we were studying because, in fact, they commissioned this study, this being the first fully online tribunal in Israel. And still, data availability and the quality of the data, even when it's gleaned from a fully digital case management system, were an issue. And they limited our research. They limit the kind of conclusions that we can draw from this research, which is why, if there is one takeaway that I want you to take from this presentation, is the importance for bodies implementing ODR to develop a data strategy early on at the design stages of the platform. This means being aware of what needs to be collected and thinking about how to design your platform in a way that enables that. And oftentimes when we are countering this with a previous process, it also means collecting baseline data of the previous process in ways that are comparable to the data that we're collecting about ODR, because otherwise it's just very, very difficult to draw any meaningful conclusions. The second takeaway is about the importance of using a mixed methods approach. I'm going to show you a research that was based on observations and surveys and docket data analysis and interviews. And each one of these methodologies actually told us a different piece of the story, and the story wouldn't have been complete without all of those. And there were blind spots for each one of these methodologies. And this is particularly important because I think especially decision makers like Excel spreadsheets and nice tables and graphs, but oftentimes it's qualitative data that tells us very important stories too. And lastly, the fact that we in the legal industry and public bodies are resistant to A/B testing within legal proceedings is a challenge. And it's a challenge because at the end of the day, all of the platforms that we've heard of today, and even the different studies that we've heard of today, are extremely context-specific. There are always a lot of caveats and limitations that we have to state about the applicability and the generalizability of our findings. And if we really want to test the impact of the medium, of synchronicity, of different design features within our process, then we have to use randomization. We in academia like to call it randomized controlled trials. The web designers of the platforms would like to call it A/B testing, but it's the same thing, really. And we have to have that in place in order to really draw conclusions about causal relationships between our design and experiences, outcomes, and other features that we're interested in. Okay, so this was basically the end of my presentation, but now I'm going to tell you how we got to these conclusions, time permitting. So the research question that we embarked on into this study, again, and this was a commissioned study by the Ministry of Justice, were first of all, is the institutional design that was selected for this particular proceeding useful, successful? Are there any things that need to be reconsidered as this model is being expanded to other tribunals within Israel? I'm not going to touch so much about that here. What I am going to focus on here is to what extent do the different modalities that we have within this proceeding affect the ability of the process to achieve its goals and the values that we hold dear in terms of the process. So we looked at efficiency, at accessibility, at procedural justice, and also at the distribution of outcomes and the perception of outcomes among participants. Then it was a really interesting opportunity to examine within a specific setting two different modes, right? The online video versus online text. It's not perfect, again, limitations, because these were tiered one after the other, and there may be some unique attributes of those cases that proceed, right? But it's the best we've got, actually, so far. We don't have any empirical studies looking at these types of comparisons. And then we had the chance to look at the impact of representation. We are talking about the promise of ODR to enable supported self-representation within these proceedings. What happens when we have a single ODR process where we have both represented parties and unrepresented parties? Do they fare differently? And so, as I mentioned, we used docket data analysis, surveys, and interviews. We also had about 20 observations that I'm not reporting on here today, but you can know that it happens. In the interest of time, I'll skip the specifics. I'll just say, for the sake of other people who are running surveys, that getting a reasonable response rate for your surveys and avoiding self-selection for voluntary surveys is a challenge. We try to avoid that. We got from the tribunal the full list of all the appellants and the representatives, and we had a student call each and every one of them to notify them about the survey, explain the importance of participating in the research, and we got a 35% response rate at the end, which may sound low, but this is actually tremendously high for comparable studies. And there's still probably self-selection, and we did have some, we had a lot more lawyers fill out the surveys, for example, compared to the relative part of the population. So there are issues here, but whoever is relying on voluntary surveys to say, we're doing great or we're doing terrible, that's really a problem, right? We can't really design policy based on that because of the self-selection problem. So this is data that I'm showing you from the docket data that we got. We essentially had about 35% of the appellants who self-represented. The rest were represented by either accountants and tax advisors, actually the majority, and about 15% represented by lawyers. Then in terms of the technological mode, about a third were involved also a VC hearing. I think that's kind of the gold standard. Everybody says it's going to take about 30% of the cases will need that extra involvement of the judicial officer, and that was the case here too. In terms of the characteristics of the appellants that actually got into the process, this is the appellants by annual revenue. You can see that the majority, the large majority, had, this is in shekel, right? It's shekel is about, now it's actually terrible. It's almost four shekels for $1, but that's about for US dollars, the ratio. So it's not really the smallest of businesses, right? The reason for that is really that because of COVID and, again, selection issues, at some point the tax authority was so overwhelmed by the petitions that it got for grants that it just auto-approved all the lower sums because they couldn't handle, they didn't have the manpower to do any of that. So it's not because they wouldn't come to the panel. So again, context matters. In terms of the findings, so I already mentioned that we did the tribunal did very well on all key metrics, but I would say that we had more favorable procedural justice experiences in processes involving VC. We suspect, as you'll see soon, that this is because of the ability to express oneself or to have voice in these hearings. How much more? It's about 10% more. And this begs an interesting question of how much is 10% more procedural justice experiences worth, right? How much should bodies invest in terms of infrastructure, of the time, the cost of holding these hearings, and also some of the complexities that perhaps some participants would have in participating in these hearings compared to asynchronous text-based proceedings. But this is a policy question that data helps us at least think about. The process was experienced as professional, as respectable, as allowing voice, though, on really both modalities. Efficiency was perceived as very high by all participants, and it's also showed to be very high by our docket data. Nearly all cases took less than 3 months to resolve, which is extremely quick compared to any other comparable tax appeal that we have in Israel. And generally, we had very positive access perceptions as well. The process by the majority of participants wasn't experienced as complex. They felt they understood it. And that is also supported by our docket data when we look at how much it costs to participate and the time that it took to resolve. And essentially very few technical problems hindering access, at least in terms of the virtual hearings. But as I mentioned, still about 30% prefer face-to-face. That's a nice big picture to tell. I want to dive a little bit into the details. So when I say access was perceived to be, that access to justice had very high results here, yes, about 84% of the participants thought that the process was not complex. And as you see here, about 70% thought that the process was very understandable. But what about those who disagree or partially disagree? So this is more than 25% of the participants. We as designers of these platforms, or we as evaluators of these platforms, need to think about those 25% or more. What are we going to do? Because our average looks great, right? And the majority likes it, but there are still those 25%. How are we going to design a process that is better for them as well? I want to say in addition to those perceptions, what we could learn from our other mixed method methodologies. So in interviews, we learned that having a protocol for conducting the hearings and supporting the hearings by the administrative staff of the tribunal was really perceived as a key factor in those hearings being experienced as accessible. We found out that the 24/7 access was really meaningful to some of the participants. So we always say that on paper, but we actually had people talk about that, not just about their ability to do it, and this maybe goes to Frank's point about how busy the tribunal is. They were so impressed by the fact that judicial officers rendered a decision at 6 a.m. and that they got them. And that that the non-standard office hours were also experienced as having access. And then in terms of the docket data, we saw that the way that self-represented litigants use the process on a lot of accounts is very similar to the way represented parties use the process. There were some differences. We won't touch upon them today, but for the most part, they were using the process similarly, which shows that it's accessible to parties. Okay. In terms of efficiency, this is an interesting part where mixed methods can really help. We see that in terms of the docket data, the duration of the proceeding was great. The majority resolved within 3 months, which is really amazing compared to other processes in Israel. And yet, in the survey, we got quite a lot of parties say that they felt that the process took a very significant time investment and took long. We didn't really understand this finding until we realized, what I mentioned earlier, that they experienced the entire process from the first day they filed their initial filing within the tax authority until they got the tribunal judgment as a single process, because they didn't distinguish between the tax authority and the tribunal. And then we also found out, in terms of efficiency, that different representatives experienced the process differently. While attorneys were really happy because they could bill for the hours that they invested in the process, tax advisors and accountants were really unhappy because they were on retainer, and this took additional time, so they thought the process wasn't that efficient. So here again, we see that context matters, and this is information that we only got from interviews. I guess what everybody is most interested in is procedural justice, the hallmark of what we're trying to achieve with these processes. Here you can see various measures that we use for procedural justice. These are based on, of course, the vast literature on procedural justice in social psychology and in law. What I want to draw the attention here to, so green is essentially good. We see that there's a lot of green there. And that's good. We're happy about it. Policymakers were happy about it. They expanded this model to other tribunals. But look at the red. What are the red and yellow telling us? So we see that the process was perceived as objective by most, but about 25%, again, don't feel that this process is objective. Again, this goes to the story that I told you about tribunals. We've talked about that. We also see that there's a challenge with opportunity to present arguments that we might want to drill down into. When we drill down into it, we saw that there's a difference, and this is what I mentioned about the difference between proceedings in writing and proceedings involving video conference. It matters, right? In processes that were text-based only, procedural justice experiences were lower. And we see a lot of red that we don't see in the processes that involved VC. This is interesting. What do we have to do in order to make sure that people who are participating in text-based only proceedings feel that they had voice, that all of them feel that they had voice? Or alternatively, how do we find out ahead of time who are those people who would not experience voice due to whatever attributes that they may have in order to understand this? So when I was asking Simi earlier about user attributes, it's because of these kinds of findings. If we can identify who they are early on, then we might be able to triage it and direct them to a different process. In the interviews, we found out some additional interesting findings about the procedural justice. One has to do with the trade-off between efficiency and fairness. We oftentimes ODR proponents take pride in the efficiency of the proceedings, but for some participants, interestingly, this was actually tax authority representatives, this efficiency was problematic because they felt they could not fully get their day in court because of it. In terms of opportunities to voice, we also realized within these proceedings that actually some of the fears that I think also Frank earlier mitigated, that it will not be a respectful process, or that a face-to-face hearing is superior in terms of the civility or the aura of the process, were actually mitigated in our interviews where people were quite happy about them. And then we also found some interesting findings that we wouldn't have otherwise discovered. For example, especially one-shotters, to use Mark Galanter's term, so people who only used the process once and were not represented, didn't always know that they could ask for a hearing. They didn't know that it's not just the discretion of the tribunal, but it's also a right that they have to ask for it. And so they didn't ask for it. And then they found out later from other people that that was an option and were not happy about it. So some other findings that could improve the design of the proceeding. How am I doing on time?
You still have 5 minutes.
Okay, great. Here I'm just going to bring together those various insights that I mentioned throughout my presentation. The difference in procedural objectivity in text-based processes versus processes involving video hearings, the perceived time investment versus procedural duration, the questions of whether the digital interface really obscures the distinction between the bodies. Our thinking about this started from this interview where the person said, I clicked on the link and I didn't understand at all that I moved from the tax authority website to the Ministry of Justice website. I thought I was still at the tax authority. When I received the response of the judge, I realized that I was at the Ministry of Justice and that I moved to a different procedure. And so that initial insight is what led us to go dig in the data and look for supporting evidence for this idea, just to show that it's important to have that kind of method implemented within any evaluation project that we go through. We also tried to look at what explains that 30% preference to face-to-face hearings. I want to say, and this also has to do with the study that Frank noted, this is perceived face-to-face hearings. So this is the idea that respondents have about what a face-to-face hearing would look like, because we didn't have that alternative here. So whenever we are asking people to compare their perceptions of, it's what they imagine of that process would look like. So that's an important thing to remember. But what we try to do here with the presentation of information in this way is to see whether being a representative or being a self-represented litigant, and whether having participated in a video hearing or just in a text-based process affects what you would prefer in additional or is related. I don't want to use the word effect. Is related to what happens to your future procedural preferences. And what we see is that essentially, if you've participated in a virtual hearing, most people like that. They want to do that no matter what role they're in. But if you participated in a text-based process only, your role in the process matters. So lawyers, for example, are less convinced by it, but appellants were quite happy about it. Why? Is it because they don't know what's good for them, because they're self-represented? Is it because of the attributes of these cases that resolved quicker and because they were awarded everything that they asked? We don't know, right? We only have these perceptions. So in order to understand what's the meaning of these findings, it's not enough to just present them. We have to drill down. Sadly, we didn't have the ability to link the responses to the case data, so we don't know how that happens, but it's an example of why connecting surveys to docket data or running RCTs is important, because then we would have been able to do that. I'll wrap up. So some of the challenges and limitations, and my call to anyone here who is involved with a tribunal or a court and would like to have researchers help them evaluate and improve their system, what to do with data. First of all is be more generous with access to your data. We had a wonderful partnership with the tribunal in Israel, because they actually really needed it, because they wouldn't get funding unless they showed results. So they were actually interested in it, very invested in it, spent a lot of hours helping us figuring out missing data and inconsistencies within the data. The more you have manual work implemented within your process, if you have administrative staff input categories, case type or some attribute of the appellant and so forth, the more inconsistencies you're going to have. And what we found out through the research is that actually different tribunal judges were thinking differently about the categories within the system, so they would categorize them inconsistently. We couldn't use that. We wanted to see whether the topic of the appeal or some other attributes of it are related to any of our other measures. We couldn't do it because there were so many inconsistencies. Then we also didn't have benchmarks. In this case, it's because it was a new process. But oftentimes, it's when we implement an ODR process as an alternative to an existing process, we don't have benchmark data to compare to. So this is really important. Collect it before you make the change so that you can see the impact. Stakeholder data. This is a real issue. Recruiting users to participate in these studies is always a challenge. This is the low return rate that we see in surveys. It's the difficulty of getting interviewees to actually talk with you, especially, you know, in court studies, you would just, you know, sit outside the court and just grab them, and eventually you'll convince some people to talk with you. In an online process, that's a lot harder. Your emails are being ignored, your text messages are being ignored, so you need some way to recruit participants. Access to judges. This was really important. We were allowed to interview judicial officers for this study. Oftentimes, there are a lot of complexities with ethical rules on judges, but that's a very important perspective to include in such studies. And we learned, I should say the hard way, that there are some issues with anonymity and privacy that need to be taken into account, especially if it's a small tribunal with not so many judges or representatives, say, of the authority. Like sometimes you would have maybe 4 or 5 lawyers represent the governmental agency. Respecting their privacy and anonymity is really important in order to make sure that you don't reveal any identifying information. No random assignment. I'm going to say that like for the 4th time maybe. That's really necessary if we ever want to know what's really happening, because everything here has limitation. Everything that I've presented is based on the specific context of the process. There are other attributes we are not, we don't know of. Are there different attributes for cases that go to a hearing or not? I don't know, but if I had cases that would randomly be assigned to a hearing or no hearing treatment, I would be able to say more about it. And then, again, the context sensitivity. This is a very unique process. I emphasized that as I started that, you know, our self-represented litigants are businesses, some small, some large, but they're still businesses. This is not your classic self-represented litigant. So there's limited generalizability of the finding. So this is sort of a call on all of us, to be careful as we try to develop recommendation based on findings of other projects, and why it's important to have individual research in each and every body that does that. So I can stop here, and if you have more time later, I can tell you about some other projects and other conclusions that we had based on them. Thanks, everyone.